Good evening and welcome. I'm Praveen Fernandez, Vice President of the Constitutional Accountability Center, otherwise known as CAC. For those of you unfamiliar with us, CAC is a public interest law firm, think tank, and action center dedicated to fulfilling the progressive promise of the Constitution. 10 years ago, CAC published Laying Claim to the Constitution, a piece by Professor James E. Ryan that described the methodology that informs all of our work. The piece explained how fidelity to the text and history of legal documents, whether the Constitution or statutes, was something that progressives could embrace, regardless of what conservatives would have you believe. 10 years later, so much has changed, which prompted CAC's decision to reissue Laying Claim, but with powerful new introductory essays. And who better to discuss this with this evening than the authors of those introductory essays? If I gave them the introductions that they deserve, we could easily exhaust the entire hour, so I'm going to be very brief. And look down just to make sure I don't miss anything. But CAC's first speaker is CAC President Elizabeth Wydra, who was actually the first person to be hired by CAC's visionary founder, Doug Kendall. Aside from Elizabeth's progressive appellate litigation, you might know her also from her frequent media commentary on legal and policy issues of the day. Our next is Alexis Hoag, who is assistant professor of law at Brooklyn Law School, where her scholarship focuses on criminal law and procedure. Prior to joining the academy, Professor Hoag spent more than a decade as a civil rights and criminal defense lawyer at entities such as the NAACP Legal Defense and Education Fund and the Office of the Federal Public Defender. Our next speaker is Katie Eyer, who is professor of law at Rutgers Law School, where her scholarship is focused on anti-discrimination law. Her 29 article, Statutory Originalism and LGBT Rights, 2019, I said 2009. I made it longer than it was. Even more prescient, her 2019 article, Statutory Originalism and LGBT Rights, has been credited with originating the argument that the Supreme Court ultimately adopted in its landmark 2020 case, Bostock v. Clayton County. Prior to joining the academy, Professor Eyer litigated in the area of LGBTQ employment rights. So welcome all of you. We're so glad to have you here for tonight's discussion. Elizabeth, I'm going to start with you. As I said, not only as CAC's president, but you were also one of its first employees and tapped by Douglas Kendall, and you were there when this publication came out. Can you tell us what the aim was of the original Laying Claim and what you were going for when you decided to reissue it?
Yeah, thank you so much, Praveen. Thank you for that lovely introduction. And I want to first take the opportunity, before I answer your great question, to thank Professors Hoag and Eyer for being here tonight to talk about this publication with us, and also for their spectacular essays that they added to our re-release of Laying Claim. I'm extremely grateful for their scholarship in general and for their work on this particular project. And I'm so excited for our conversation. So yeah, exactly. You know, when we first released Laying Claim to the Constitution 10 years ago, you know, this was in some ways a new entree to progressive legal constitutional interpretation. The idea that progressives should and can enter the debate over the Constitution's text and history, what has often been termed originalism, on extremely strong ground. Doug Kendall's vision for CAC and for having Professor Ryan, now president of UVA, put together the Laying Claim original essay was that if you look at the whole Constitution, its arc of progress, the amendments made to the Constitution, especially those after the Civil War that dramatically remade our Constitution such that it has been appropriately termed the second founding. If you look at that arc of constitutional progress, it strongly supports progressive outcomes, and progressives should embrace that constitutional text and history, should embrace textualism, rather than running from it. And this idea that the labels over judicial method were what the fight was about, whether it was conservative originalism or progressive living originalism, progressive living constitutionalism. The idea was that we've moved past those labels in an important way. That was one of the main points of Professor Ryan's original laying claim essay, he laid out the way in which there had been a consensus among jurists. He talked about the ways in which the confirmation hearings featured fairly similar language from Chief Justice Roberts and Justice Elena Kagan, obviously on different sides of the ideological spectrum, but they both had a consensus that you start with the words. And then he detailed the way in which there has grown this progressive scholarship showing the ways in which the text and history of the Constitution, and importantly, the whole Constitution, I think especially if you look at the 13th, 14th, and 15th Amendments, but also other amendments to the Constitution as well, this growing scholarship gave progressives very real ammunition in the debates over the meaning of the Constitution. And so that original document was to show that the fight is not really over labels, but over what the Constitution means. Now, looking back at that 10 years later, obviously things have changed for better and for worse than the landscape against which we originally released laying claim. In one sense, there has been an increase in the progressive scholarship showing the way that the Constitution's text and history supports progressive outcomes and supports moving toward greater equality and meaningful justice. I think a lot of that work with respect to reproductive rights, LGBTQ equality, racial justice, a lot of that has been extremely important and it has grown and developed in this past 10 years. But we've also seen the judiciary swing wildly to the right, with judges put on the bench in the unprecedented push by Trump and McConnell to get the bench to be much more conservative, including, of course, the Supreme Court. And so arguments that are rooted in originalist theory, that are rooted in textualism, have become more important than ever if we ever want to succeed in the Supreme Court. And as you'll see in, for example, the essay by Professor Eyer, we've been able to do that in key cases that have to do with LGBTQ equality, for example, and there's hope that we can continue there. But another reason why I thought it was important that we re-release this argument for why it's so important for progressives to argue about the meaning of the Constitution itself and not just over labels is because there's real power when we root our arguments in the words of the Constitution itself. Because so many of the things that we are asking for are promised to us in the Constitution. And just because the courts may have gotten it wrong, may still be getting it wrong, and just because Congress might not have acted in ways that the Constitution requires them to, thinking about some of the ways in which the 14th Amendment promises equality and justice, lived equality, lived justice. Just because the courts have gotten it wrong or Congress hasn't stepped up doesn't mean that our demands for change are not rooted in the progressive promise of the Constitution. And I think reclaiming the document from a repressive reading and reclaiming it toward one that tends toward liberty as a matter of principle is something that's important and powerful. And I think the two essays that we added to Professor Ryan's original essay from Professors Hoag and Professor Eyer, Professor Hoag and Eyer, they show the way that the Constitution can really shine a path toward greater equality for all of us.
Thank you so much, Elizabeth. And you've perfectly set up, our next speaker, because of course, it brings us to our new introductory essays. Professor Hoag, for those who haven't had the great fortune of actually reading your essay, do you want to give us, a quick synopsis of what you were trying to add in this new reissue with your essay?
Yes, thank you. And I just want to start first by thanking CAC and Elizabeth and Praveen, you and your colleagues, David Gaines as well, for inviting me and also Professor Eyers to participate in this conversation. It's something that in my transition away from advocacy into the academy, I turn constantly to the legislative history, particularly the Reconstruction Amendments, as I think about how best to advance and advocate for racial equality and equality really for everyone. And so I was just delighted to be able to contribute to the essay and to also be part of this conversation this evening. And I want to preface with, this is an ongoing conversation, and I hope that those that are tuned in will feel free to utilize the chat, and then, obviously to hit us up after this hour talk. But my essay is called Reclaiming Reconstruction. And it looks primarily at the 13th, the 14th, and the 15th Amendments, and then also just the energy that existed at that time in this country. And I lean heavily on the work of Eric Foner. He's primarily a historian at Columbia University, Dorothy Roberts, who's a law professor at Penn, and others. To draw inspiration really from that period in our nation's history. And when I think about the founding ideals of this country, we have come up short. And Reconstruction was the most transformative period politically, economically, socially in this country, really since the beginning, the founding documents in the late 18th century. So here we have, in the wake of the Civil War, an opportunity not necessarily to expand rights, expand citizenship, but to recognize that Black people are citizens. And they are citizens with all of the privileges and the immunities that citizenship entails. We all know that we have a negative sort of rights constitution. And so the way that those amendments were drafted was to recognize Black people as citizens for the first time, and then to prevent others from encroaching upon Black people's exercise of their citizenship. And so when I think about how best to advance the rights of marginalized people, that's where I return to. And I look at the 39th Congress, which was what was convening right in the wake of the Civil War. And they have this awesome responsibility of how to bring this nation forward, how to repair this nation. And they presided over, there was a joint Reconstruction sort of committee of senators and members of the House of Representatives that came together and heard testimony from, I want to say, over 150 individuals that were still occupying the former Confederate states. And they testified to this joint committee, and they said that Black people have no protection from assault, no protection from rape, from murder, from destruction of property. And there is no one they can go to at the state level to seek protection. And so Congress, this committee, upon hearing this testimony, drafts portions of the 14th Amendment, drafts what would become the Equal Protection Clause, and realized that they had to open the federal courthouse doors to create a forum for people whose rights were being denied to then secure those rights and get those rights protected and recognized, acknowledged, and enforced by the federal government. And that's what I think about with the 14th Amendment. And that was the potential of it. But of course, we know the court later interpreted it in a much more narrow way, and really prioritized private enterprise, prioritized property rights over individual liberty and equality. But the seeds are there. And so in my essay, I really encourage advocates to look at that period in our nation's history, and that promise, that aspirational sort of promise that, again, is yet to be fulfilled, to go back and to look at that as sort of ammunition for advancing the rights of marginalized populations. And to me, the Reconstruction Amendments, they've yet to be fully recognized. And so I find it particularly exciting looking at sort of my peer group of junior scholars. So Brandon Hasbrock is a colleague in a greater sense at Washington and Lee Law School. And he has these two recent pieces out on utilizing the 13th Amendment to abolish racist policing, and looking at the Constitution as an anti-racist document. And so he is not doing, he's not looking at sources that are new and different. He's looking at these original documents, these original texts, these original conversations from this period in our nation's history, and then reinterpreting it today for 2021. And I find that progressives have been slow to engage in that kind of analysis. And so I'm just excited to sort of be a part of this community of thinkers and advocates to really utilize the text, what we already have to work with, to advance equality, advance really progressive ideals. So I'm looking forward to more in the conversation.
Thank you so much, Professor Hoag. I loved your essay and its powerful interchange of using history, particularly the Reconstruction Amendment history, to sort of mine and contribute to meaning. And just as your essay was focused on a text, the Constitution, our founding charter, it brings us to our next essay by Professor Eyer. And in that case, of course, you're talking about the text being simple statutes and applying sort of an analogous conversation about mining for meaning, et cetera. And so, Professor Eyer, for those who haven't had the chance to read your essay, could you give us a little bit of a synopsis of what you tried to cover in your essay?
Absolutely. And let me start by saying what a pleasure it is to be here tonight with all of you. Thank you to the folks from CAC for inviting me to contribute this essay and for being a part of the conversation here tonight. So as Praveen has alluded to, my essay is really focused on a particular corner of this conversation, which is encouraging progressives to embrace textualism in statutory interpretation. And I should start by saying that I think from a strategic perspective, that this argument really is a very straightforward one. As we're going to talk about later in the panel, textualism is the ascendant method of statutory interpretation today at the Supreme Court. And if you look around, there are innumerable subject areas where it is strategically valuable to progressives to be making textualist arguments. So that's actually not the piece I want to focus on in my introductory remarks. What I want to focus on in my introductory remarks is what I think is the harder case to make for many progressives, which is that there are principled reasons why people across the ideological spectrum should embrace textualism in statutory interpretation. And to make that case, I want to focus on a particular value, which is the value of ensuring that all groups have equal access to the protections of the law. And I want to make the case that if we care about that value, if we care about the law serving groups equally, serving folks who are not the privileged, but the less privileged in society, that we should care about the embrace of textualism. And to make that case, I want to start off with just a descriptive observation, which is if we look across the span of history at the places where judges have gerrymandered text and sort of gone outside of what the text says, it has most often not been to the benefit of racial minorities or poor people or people who are not politically connected, but rather to the advantage, right, of the powerful, the racially privileged, and the wealthy. To some extent, this should come as no surprise, but I think it runs counter to the narrative of textualism as a sort of Trojan horse for conservative values. And we can see this phenomenon of departures from the text sort of benefiting the wealthy and the privileged and disadvantaging those who fall out of that scope across a wide array of contexts. We can see it in judges carving out individuals for those who are privileged, those who are wealthy from the application of the criminal law. We can see it in judges conversely carving out disfavored groups from the protections of rights. And we can see it perhaps most prominently in the context of judges adding non-textual limitations to some of the truly revolutionary statutes that were intended to upend status relations in this country and to benefit historically subordinated groups. So across all of these contexts, it can allow inequality to leak in and the law to mean one thing for the rich and the powerful and something else for everybody else when we don't treat text as our lodestar. There are a lot of different examples of this. But in my brief remaining time, I want to focus on one that may be especially familiar to many of you, which is the case of Holy Trinity versus United States. Most of you have probably heard of Holy Trinity as a favored object of derision for textualists like the late Justice Scalia. In Holy Trinity, of course, the court states openly that it's departing from the broad language of the statute in order to follow what it perceived, probably correctly, as the congressional intent. Now, Holy Trinity is often held up as this sort of dry and academic example of purposivism versus textualism. But if you dig a little deeper into the backdrop of Holy Trinity, what you find is actually a story of inequality. So the law at issue in Holy Trinity used broad language to make it a criminal offense to, quote, in any way assist or encourage the importation or migration of any alien or aliens into the United States to perform service or labor of any kind. But if you look at the legislative history, what you find is that Congress was really concerned with a particular practice, which was the importation of poor laborers from countries that were perceived of as lacking in American values. So the court in Holy Trinity almost certainly got it right when it found that Congress would not have intended this criminal law to reach the work of a white minister from England, and when it concluded more broadly that the law was intended to reach only the work of, quote, the manual laborer, as opposed to that of the professional man. But I would suggest that we ought to be more, not less, troubled about the court's departure from the text of the law if that is the case. Allowing the courts to read non-textual limitations into a criminal law based on the classist and nativist sentiments of its enactors, that's something we all should be deeply concerned about. And we should be just as concerned today about that type of gerrymandering of the law as in the era of Holy Trinity. And this is something that I think textualism alone is really uniquely situated to serve as a bulwark against. So I'll go ahead and conclude there. But again, I'm really looking forward to the remaining dialogue on the panel with all of you.
Thank you so much, Professor Eyer. That was so helpful. And I'm more excited than ever about opening up the discussion to everyone. Before I do that, I wanted to let people know that there is a way, in fact, to ask questions. We're going to have this open discussion, and then we're going to have the last 15 minutes or so be open for audience questions of our amazing panelists. So I'm going to give you a little message from the wonderful folks who are running the tech here. So this event is streaming on Facebook and YouTube. And for anyone who wants to ask a question of our panelists later in the program, be sure to sign into your account, and that will allow you to submit your question. So, and I will remind you about that before we get to the Q&A portion again. So thanks so much. Start thinking about your questions because these are amazing panelists, and I want to make sure that they get to all of your thoughts that are prompted by the discussion. So I'm going to start with, Professor Eyer sort of talked about meaning, and several of your remarks have talked about essentially being faithful to original meaning. And I think it's important maybe to sort of level set a couple of things. One, what we're not talking about protecting when we talk about original meaning, because I think sometimes there can be a bit of a straw man. There's an argument that what we're protecting is maybe the original intent. And Professor Eyer, your essay takes this on. What is it that we are being faithful to? What is it that we are not, considering we're talking about original meaning? And what is the role of history?
That's a wonderful question, Praveen. And one of the things that I think is most important as I've really developed my work on this issue, both in this essay, but also in other sort of farther reaching work that I've been doing, is that it's really important at the outset to be thinking separately about textualism and originalism, and to understand that some versions of originalism actually aren't consistent with textualism, and also open up lots of opportunities for the type of inequality in the application of the law that I was just alluding to. So my own view is that when we're talking about history, and in particular here thinking about uses of history that fly under the originalism flag, it's really important, again, to pull those two things apart and to make sure that the ways we're using history are consistent with fidelity to the text. Because again, some of these uses are consistent with that principle, but many others really are not. So if you think about a sort of original expected applications approach, Do we think the original framers or the original public would have expected this particular application? When that question is asked in the context of broad language, it can easily devolve into a situation in which a court might speculate, well, everyone's going to get the benefit of this broad protective principle, but not you, disfavored group, because we don't think you would have been expected. So to give an example of this, if we're thinking about the Bostock case, right, this was precisely the type of reasoning that was used by both the dissenters and the defendants in that case to say, even though we've said that because of sex means this, it means but for sex, even though that principle should reach LGBTQ folks, we're going to say because the original public wouldn't have imagined this because LGBTQ people were stigmatized at the time, we're not going to include them in these protections that extend to everyone else.
Thank you. Others?
Yeah, I just wanted to add to that. I think that's a great example. You know, the Bostock example is a really fantastic example of the ways in which, you know, you start with the words. And that is the most important part of whether you're doing statutory or constitutional interpretation, is starting with the words. And the fact is, especially when you get to, you know, we're talking about the Constitution, you know, Professor Hoag talked about the 13th, 14th, and 15th Amendments. The words in those amendments are broad and radical and inclusive. And so were there people who voted to ratify that amendment who had racist, sexist, other bigoted personal beliefs? I have no doubt. But what they voted to ratify is broad and inclusive and in many ways revolutionary. And so that is what we start with, and that is what lives through the ages. And so, you know, I think, you know, as Professor Eyer was saying, you know, textualism versus originalism, and there are some uses of history and originalism that are not really, you know, keeping faith with the Constitution's text and history. And, you know, for that reason, like, I wish there were a better term than originalism. You know, one of the things we tried to do 10 years ago was kind of start a new term, new textualism. That didn't totally take off. That's one of the things we can look back over 10 years that didn't totally work really well. But a lot of the arguments that have flown under, you know, the kind of progressive interest in using text and history arguments, those have worked. And I think that that's important when you're talking about what are we talking about? What are we not talking about? And, you know, one of the things that I dislike about the term originalism is that I think a lot of folks think that it means the original, like, 18th century Constitution. And I think a lot of conservatives kind of have internalized that because they're like, oh, wait, I forgot about Reconstruction and the powerful ways that it changes the Constitution. But we're not talking about just privileging the original Constitution. One of the things that is so powerful about progressive text and history arguments is that you're talking about the whole Constitution and the ways in which, you know, generations have fought to put those words in. You know, generations of abolitionists and activists knew that the words in the Constitution mattered, and they gave their blood, sweat, and tears and treasure to get those words changed. And so honestly, like, I feel like we as progressives owe them to embrace their work and use it to go forward.
Yes, I actually have just an arm's reach Du Bois' Black Reconstruction in America, which was like, let's pay attention to the exact words in the Reconstruction Amendments because they mean something, and they mean a recognition of the rights of Black people. As we were just grappling with, you know, originalism and textualism, I think about sort of where this came to a head in so many of those early cases that were litigated in federal court in the wake of Reconstruction and trying to make sense, federal judges trying to make sense of how to interpret these new statutes. And there's this case that I was not introduced to until long after law school. And I'm curious when all of you heard about it, but, and I may be butchering the pronunciation, but it's like, it's Blue or Blylew, it's Blyew. It's that Kentucky Case, where a Black family was slaughtered in the late 1860s. And the case was removed by two white assailants. The case was removed from state court into federal court. And it was the first time the Civil Rights Act of 1866 was going to be tested. And in Kentucky, there was this state law that said that Black people could not testify against white people in a criminal proceeding as part of the reason why the case was removed. And the U.S. attorney secured 2 convictions and death sentences against the 2 white defendants. And the U.S. Supreme Court eventually overturned the case and said, well, these people weren't affected by because they were murdered. I mean, it was a very sort of strict textualist reading of the new 1866 Civil Rights Act. Now, when we think about the 39th Congress intent, that wasn't it. But then we saw this really restriction on the recognition of rights. And so when I think about what should we be paying attention to as progressives, yes, there's tools in the text, but these aspirational ideas that are embedded in those words. And I think all of us have touched on this, but just how transformative that period of our nation's history was. And this idea that we have not fully recognized those promises. I was thrilled, and I don't know how much of you all watched this, during the pandemic. I was watching probably more TV than I normally did. But that Netflix special, Amend, that I think Will Smith was the producer, and so many of the people that we're in conversation with were like talking heads on it. And I mean, it was just like a law professor's like nerd dream to see the 14th Amendment given that kind of attention. And I think about how Ava DuVernay and the 13th brought that into sort of lay people's discourse and understanding. And I'm just incredibly excited about the conversation we're having here, but the greater public awareness of how spectacular and how awesome. I mean that word in the literal sense. The potential is in those amendments, and just that now everyone is really getting a sense of them.
I just have to add in, because I'm so glad you brought up amend. And Praveen, you talked about kind of the uses of history and what we talk about when we're talking about history here and the Constitution. And we are lawyers and law professors and scholars, and so we kind of talked about what the courts do when they use history and how we use it as advocates. But I love, Professor Hoag, that you just brought up that public use of history. And I think that is one area in which I think it would be very powerful progressives to embrace even more, because, the conservative originalists have done a very good job of cementing this public narrative. I think almost every person in this country and probably people around the globe have an idea of the Second Amendment. And it's probably wrong, but it's, there's been a conservative effort to get this public imagination about a conservative narrative of the Constitution. And, one of the reasons why, I think it's so important for progressives to debate the meaning of the Constitution as opposed to, jargon about academic labels of whether it's going to be originalism or living constitutional, whatever. I think it's so important to talk about the Constitution itself because we have that power in that history, and things like amend, things like the 13th, bring the public into that conversation. It's not just lawyers and judges. And I think that use of history and progressive constitutional history is so important.
And, when I think about how progressives are now reclaiming or claiming that space anew, I think about all the incredible work that's happening with the Equal Justice Initiative, and uncovering and putting a spotlight on, again, this period really after the Civil War of really mass violence against Black people, and the history of lynching in this country, and tying that to mass criminalization. And I don't know if folks here on the call have had the opportunity to walk through the monuments and the museum in Montgomery, Alabama, but it is incredibly striking and drawing this unbroken thread so that we don't forget where and why and how these amendments came into play. And I'm speaking again about Reconstruction, but it was really in direct response to this idea of newly recognized citizens needing to have some forum, some legal form where they could come and seek protection. And as we talk about why qualified immunity makes no sense and should be abolished, you look back at why 1983, which came out of the Ku Klux Klan Act of 1871, came into play, was to open the federal courthouse doors and hold people in power, the state, accountable for the deprivation of civil rights. And so the look back to history is so critical to the types of arguments we should be forming and to the advocacy that we're advancing.
And that conversation and that look back to history is so important, not only for those constitutional provisions, but again, for the statutory backdrop that is also this conversation that's happening, right, with these rights that are sort of newly recognized in this set of amendments, but individuals who are not able to find justice and vindicate those rights in state courts. So there has to be a federal mechanism. And it is absolutely that backdrop of exactly that violence that Section 1983 is trying to address. And it is that actual factual backdrop that courts are ignoring when they concoct out of whole cloth this qualified immunity doctrine. And so I love that this conversation is going towards issues, because as interesting as a conversation about methodology is, and to be clear, I'm interested. I think, for so many people, their entry point is the issues they care about, right? So progressive issues they care about, and they want to know, how is it that this is playing out? And some of these have some of you have already touched upon that, right? Professor Eyer, you mentioned people who are working on LGBTQ rights, how a reaction about like a textual reading of Title VII of the 1964 Civil Rights Act functioned in a way that allowed LGBTQ employees to be protected. You've certainly talked about qualified immunity, but I'd love for each of you to talk about a way in which this methodology is today in the courts playing out for issues that progressives care about. And you can pick any issue, so.
I'm happy to play my role as the person focused on textualism, which again, often cuts, I think, in the same direction as originalism when the two are working in tandem. And I'd actually like to pick up where Professor Hoag left off, right, which is with qualified immunity. Qualified immunity is an excellent example of a doctrine that not only the sort of historical backdrop of Section 1983 should tell us is impermissible, but the text of Section 1983 should tell us is impermissible. There is nothing in Section 1983 about qualified immunity. And even conservative justices like Justice Thomas have recognized that and have called for a reevaluation of the doctrine. This is true literally all over civil rights law. If you start looking for it, you realize there are all sorts of non-textual limitations that judges have added to civil rights law that radically decrease the potential of those laws to effectuate the type of transformation that they are intended to do, that Congress intended them to do. There are lots of other places, I have to say, again, working on this issue, as soon as you start looking for it, it's everywhere. Recently in the Ninth Circuit, Jay Bybee, no wild-eyed liberal, right, had an important decision saying that that affected literally hundreds of undocumented immigrants, saying the government here has stretched too far this criminal law, trying to say that illegal entry could exist in these circumstances, and those hundreds of convictions are being overturned on that basis. If you look at a case like McGirt versus Oklahoma, the same term as Bostock, right? The Supreme Court says the property rights of Native Americans have to be interpreted as written, right? That the language of treaties means something, and you can't just say, oh, well, Congress implicitly repealed this. So I think there are examples all over the place of the ways in which simply looking at the text of the law as written, whether that's statutes, treaties, or the Constitution, really matters for issues that progressives care quite a lot about.
Yeah, and the criminal equivalent to Section 1983 is Section 242, Title 18. And again, these statutes, we call them by different numbers, but they originated out of legislation that was passed during Reconstruction. And like in the civil context, the criminal context in federal court is supposed to hold actors accountable who have deprived individuals of their civil rights under color of law. And so I want to say that the Department of Justice, they'll do an investigation and they'll determine whether or not they can bring charges. Often it's against law enforcement officials, whether correctional officers or police officers. And this is severely underutilized. It was severely underutilized under Trump's administration, AG Barr, and it's not really flexed as much as it could, even under Democratic administrations, because the courts have really narrowed the ability of the Department of Justice to secure a conviction in this context. And so the level of intent that is required is that, the actor has to operate with specific intent, that they're knowingly, violating the person's civil rights. And when we look again back to the discussions of the 39th, Congress in the 19th century, no, that was not at all the point. It was to provide this forum for individuals whose rights were being violated by powerful state officials and actors to get relief. And whether that was a criminal conviction at the hands of the Department of Justice, or in the civil context, in what we now call, Section 1983, but it's the court's interpretation that has really prevented that kind of redress. And Professor Ayers, I'm so glad you brought up Justice Thomas, who is not a fan either of, qualified immunity. And here we have strange bedfellows with Justice Sotomayor. And when you read their dissents in these cases, they walk through history. And they walk through the aspirational intent of the Congress when they passed these statutes to really, again, open the courthouse doors. Access to justice for populations of people that had no forum for relief and had no path to remedy.
Yeah, and I would just add to those great examples, two issues that are one issue that's definitely before the Supreme Court this term, abortion rights, and another issue that very likely could be before the court, affirmative action and race-conscious measures in education. Both of these issues have extremely powerful progressive text and history arguments in support of these arguments being made by progressive advocates. I think so many of us have looked to precedent when we're thinking about protecting abortion rights. The idea of stare decisis, which, I think probably everyone watching is enough of a legal nerd to know what that means, but the idea that stare decisis will save us. And even with the, increasingly conservative court over the years, thinking of Roe being, the bulwark against rolling back abortion rights. And now that we have this conservative supermajority, where even if Chief Justice Roberts votes along with the more liberal justices to uphold Roe, and I'm not saying he will, but even if he did, that you could still have Roe overturned, that requires really a return to these constitutional first principle arguments when it comes to abortion rights. And there is an extremely strong argument for finding the right to choose deeply and inherently protected by the Constitution. And we've seen in the Dobbs case briefing already, many briefs, including, I will say, our Constitutional Accountability Center brief that goes through this text and history about why protecting the right to choose abortion is an inherent part of the equality and liberty protected in the Constitution. We've seen other briefs that powerfully tie the right to choose being protected by the Constitution to racial justice and equality. And these arguments that I think a lot of progressives might not have made 10 years ago are now crucial to any hope we have of seeing abortion rights being upheld in the Supreme Court. And, there were the seeds of this planted in precedent by Justice Ginsburg, who, took the right to abortion previously being grounded in privacy and linked it explicitly to the protection for equal citizenship in the Constitution, making a very powerful argument that you cannot really be an equal citizen. Those of us who cannot have control over our reproductive capacity, you cannot truly be an equal citizen if you cannot make those own decisions for yourself. And adding to that in these new arguments that are being presented to the court, and we certainly have been making them throughout CAC's history, again, talking about what the Reconstruction Congress was thinking about when they were passing the 14th Amendment, reacting to the horrors of slavery and, looking at the horrific treatment of families and women who were enslaved and the ways in which they did not have, in the most fundamental way, bodily autonomy under the horrors of slavery. And so the idea that including that deep bodily autonomy and including the right to choose when and whether to have a child, the right for a family to be formed by the decisions of the people who are forming that family, all of these rights were denied under the horrors of slavery. And all of those rights were intended to be secured by the 14th Amendment. And so presenting those arguments to the Supreme Court saying, not only should you protect Roe because of stare decisis and precedent, but you should protect the right to choose because it is deeply protected by the Constitution. Those are important points to make. And so I think that, this is where text and history of the Constitution is crucial and vital to a progressive outcome in that case. And if the court ignores that constitutional text and history, ignores precedent, we cannot forget that they are getting it wrong, that we have that right under the Constitution. And so I think that that's one area where progressive originalism, can work in a way where I think a lot of folks, especially 10 years ago, might not have thought, but we've talked about other scholars, and Professor Hoag talked about, this kind of new generation of younger scholars who are pointing these arguments out, whether or not they would label them originalist or not. There's been more scholarship showing support for what would be termed an originalist argument in support of abortion rights. And there's also, powerful argument again for race-conscious measures in education. The Reconstruction Congress that passed the 14th Amendment also was deeply concerned about providing for equality and opportunity, particularly for newly freed individuals in the United States based on race, of course. And so the idea that you can't have race-conscious measures because of the 14th Amendment is completely crazy and contradictory to constitutional text and history if you give an honest reading of that.
Right. That same Congress, created through legislation the Freedmen's Bank. It's clear that they didn't see a tension between those two principles of sort of race-conscious remedies and the sorts of rights that were being expounded upon in the 14th Amendment. I hate to move us away, but I want to make sure that other individuals get a chance to interact with you, because otherwise I'm just gonna have all that luxury for myself. But I will say that one thing that came up earlier is that these arguments are being advanced in the courts, but also in different venues. And so when we're talking about history aside, in the reproductive rights context and abortion care context, you have certainly the powerful briefs that are being filed with the court about the constitutional bases for this right. But there's also this amazing scholarship by young scholars shooting down the false history that is just percolating out there, not only in briefs, but also, and I think here of professors like Melissa Murray, who's saying, what you're saying about state restrictions is just not true. That is actually not the backdrop of state restrictions around the time of the 14th Amendment. And so correcting both in briefs, but also in public understanding of what it was that the picture was like, and sort of correcting that history for the body politic as well as courts. So I'm reminding my wonderful colleagues, Doug and Amy are reminding the event is streaming on Facebook and YouTube. And for our audience members who want to ask a question for the panelists, please be sure to sign into your account in order to submit your question. And Doug and Amy, if questions come in, please feed them into the chat. Otherwise, I will continue to chat with Professors Eyer, Hoag, and Elizabeth Wydra. So while I'm waiting for this, we see it, there's a question. So, okay, I'm going to get to this. Professor Hoag, you wrote in your essay, you do not consider whether your retrospective examination of the Reconstruction Amendments constitutes a conservative or progressive approach. Both conservatives and progressives, for different reasons, may not understand why that is. Professor Eyer addressed some of this, but given your perception of the courts and their work, which have become so ideologically freighted, can you unpack why looking back to look forward, as you elegantly put it, is non-ideological in your view?
Yeah, when I think about how to find meaning in interpreting amendments, statutes, the law, I tend to go directly back to the original source. And I think about, early law school courses, admin and what do they call it? They're changing the name: administrative law, statutory interpretation, constitutional law. And so I don't necessarily label it, progressive or conservative, because it's part of the tools that I've learned as a law student, as a lawyer, as an advocate, and now as a professor when I encourage my students. I teach evidence this semester. I have class tomorrow morning. And before we interpret how judges, how advocates should look to the rules of evidence, I tell students, open the rule book. Let's look at the rule. And we go right to the text, and then, look at the committee sort of reports. But when trying to find meaning, where do we go to but for the original text as it was developed, and the conversations that the lawmakers were having with each other? What sources of inspiration were at their fingertips as they were thinking and drafting these amendments. John Bingham, who is, I want to say, the senator from Ohio who helped draft the 14th Amendment, looking at what was going on with him personally and his advocacy for Black people in the mid 1800s. And I think about that too when I think about what are the meaning of the words of the Equal Protection Clause. And so I don't necessarily have, a particular bent when I do that. But that's my go-to sort of methodology when I think about how best to interpret and then utilize these amendments.
Can I just jump in on that question, even though it wasn't directed to me? I just wanted to add, I think that the idea that text or history, which are sort of core tools of legal interpretation, can be claimed as an ideological tool for one side or the other is simply, if you think about it in those terms, it's obviously incorrect, right? These are basic tools of legal interpretation, both under the Constitution and as a matter of statutes. And I think it's a mistake to view either one of them as something that can be or could be claimed exclusively by one side or the other. So I think it's a really important point that these are not inherently ideological tools. They are simply the core tools of legal reasoning that we all rely on as lawyers.
Yeah, I think that's such a great point. And, I think unfortunately for a while, they were being used, more, I won't say exclusively, but certainly more by conservative advocates. And so, I think that there's this kind of unfortunate idea that if you make textualist arguments, or if you make arguments that are rooted in the Constitution's text and history, that they, that's a conservative methodology. I think if we didn't have the baggage of, Bork and Meese and Scalia, what we would be talking about would just be constitutional or statutory interpretation, but instead, and like I said, we didn't make fetch happen with new textualism as a label. I find, originalism has so much baggage, like we were just talking about, but, it's important that progressives not cede these arguments simply because they have been associated with conservative arguments in the past. And I think this new scholarship and increased advocacy based on these methods that, do support progressive outcomes are incredibly important in changing that perception.
So, right, since you made a Mean Girls reference, so part of this is about having this new generation of scholars, which are like advocating for issues that progressives care about, and also looks different than the folks who quite frankly put out those sorts of things. So that when you hear the voice that says you can sit by us in the cafeteria, the faces that are attached by that are not Edwin Meese and Robert Bork. They're Professor Alexis Hoag and Professor Katie Eyer and Elizabeth Wydra. So yeah, no, the casting and the history of how originalism actually has been used is something we're actively working against. And that is a challenge. Okay, a practical question. For so many progressives, there has long been a Kennedy brief, an argument to a swing justice. Is there going to be the rise of a Gorsuch brief that inherently is going to be more text and originalist driven because of the narrative of how those confirmation narratives have played out? These are individuals who, through their confirmation process and jurisprudence, have said that their commitments are to this methodology. So I'll leave that to you. This is the practical advocacy question.
I thought you were going to call Justice Gorsuch the swing vote. And I'm like, that's where our court is gone. It's tough. And I'm so curious how both of you will weigh in on this. But as an advocate, writing for your intended audience, I think that can be really limiting. I think we have to be just as aspirational. And as a primary advocate, I tend to think to ask, be measured in our ask and our demand for the remedy, and then maybe rely on, the amicus brief writers to make those more targeted sort of points. But I had the pleasure of working at the Legal Defense Fund of the NAACP before coming to academia. And I think a lot about how courageous and audacious Thurgood Marshall and company were for starting this law firm with primarily Black lawyers to advocate and advance the rights of Black people for the equality of everyone. And if they were strategically writing briefs before the Supreme Court, in the early 1940s, when they first started litigating under the purview of LDF, they wouldn't have gotten anywhere. They were asking for things that did not exist, that no one had recognized. And thinking about the strategy that went into Brown versus Board of Education and slowly chipping away at racial segregation in universities and graduate and professional schools. They were asking for things that simply did not exist. I think back, I was writing a paper looking at Alabama's legal landscape and what lawyers were available in Alabama. And Alabama law schools weren't educating Black people to be lawyers. They went to Howard, they went to Yale, they went to Michigan, and then they couldn't even become members of the bar. I mean, like the first member of a Black member of, I think, the Birmingham Bar Association was, well into the 20th century. And so I'm of two minds. We need to be strategic advocates. And I think maybe the place to do that is leaning on, who we select as amicus brief writers, having strange bread fellows sometimes. I think in the death penalty context, having former judges and former prosecutors make an argument can really get the justice's ears. But in terms of creating an argument you think might capture a single justice's ear, I find that might curtail how ambitious we are in what we're asking for.
So I'm going to make the argument for the Gorsuch brief. And what I'm going to say next is going to make progressives watching this roll their eyes. But having read Justice Gorsuch's book, A Republic If You Can Keep It, and having looked at a lot of his case law, I think he genuinely does believe in the importance of textualism in particular as a bulwark against inequality and as a protector of liberty. And I think we see that across a variety of his opinions, both at the Supreme Court level and at the Court of Appeals. I certainly don't agree with him in every single case, but I do think that he takes seriously the idea that when we step away from the text and allow biases to enter into our consideration, that's just not the way the law is supposed to operate. And so I think, again, if you look at cases like McGirt or like Bostock, both of which he authored and was a key vote for, I think that he really is reachable on the grounds that, it's not politics all the way down, that we should look at what the law says, and it should mean the same thing for everybody. It should protect everybody in the same way.
So as a litigator, we certainly, in the amicus kind of role, I think do play a very important part in putting together a Gorsuch brief and, or a Thomas brief. We've pitched arguments on preemption that help, state consumer environmental protections, et cetera, at Justice Thomas. And so, I do think that the Gorsuch brief is real. We've certainly written them. And, we've had Professor Eyer on our client on our briefs. And so, I think those briefs are important and powerful. I think what Professor Hoag says is also exactly right. The idea that, we aren't arguing Neil Gorsuch's Constitution. We're arguing the Constitution. And a lot of times we can make arguments that are tailored to a justice in that broader spectrum, but not being limited in our aspirations. But, I think that points to something that Professor Eyer gets at in her essay on our re-released Lang claim, which is that, there are multiple reasons to embrace these types of arguments. One is the power of the words themselves. And I think a lot of what we talked about today are because we believe in the power of those words. But then even if you don't believe that, there is a real strategic need to make these arguments when we have people on the bench who profess to be originalists, who profess to be textualists, then there's a strategic reason to embrace it, even if you don't kind of embrace it as, an actual meaningful, powerful practice, which I certainly do. So, I think that when we think about the ways in which the landscape has changed in the 10 years since Lang claim was initially released, that strategic point, I think, has only been made more vital.
Right, whether fueled by an actual ideological embrace and the notion of honoring documents that have gone through the democratic process for their adoption, or pragmatism, saying that we're going to lay this argument in a way that at least is consistent with the professed commitments that you've had, just makes sense. I will say that the worst part of my job is wrapping up a conversation, because honestly, I feel like I could speak all evening with you and continue to learn new things for every minute of that conversation. But I'm going to end with a thank you. Thank you so much, Professor Eyer, Professor Hoag, for being part of a product that I know Elizabeth Wydra cared deeply about, because she was here when the original document came out with as this intellectual sort of foundation for the organization that both Doug Kendall and Elizabeth Wydra loved so deeply. So thank you so much for being part not only of the product and the reissue, but also this conversation. We're in debt to you.
Thank you so much. It was a pleasure to be in conversation with all of you.
Absolutely. Thank you all. It was a real pleasure.
Thank you so much.
Thanks so much. And for those who want more information, please go to our website at theusconstitution.org. There, it's running across the bottom of the screen. Thank you so much. Thanks for joining us this evening.